Hi, and welcome to our exam number 2 video review. This is going to be the second time I did it. The first time, apparently, it did not record it. So, although I did get my daughter to help, and you can see because we have a nice green screen with Grand Cayman behind it. So the first thing we had talked about was intentional torts. And again, remember the elements of them, as well as what it takes for each. So assault. Again, assault is when you anticipate being battered. So that's me throwing, again, the eraser at somebody right before it hits them. Battery, then, is actually the contact. It requires the physical contact, harmful or offensive touching. It requires someone to physically touch your body or touch you or something in your hand or pull this out of my hand. Some type of physical touching. Defamation, again, was a false or misleading statement of fact. Remember with defamation, though, it's got to be a statement of fact. Not an opinion. You can state opinions all you want. As long as they're expressed as opinions, it can never be defamation. If it's stated as a fact, then it could be defamation. Again, also remember with defamation, there are certain the defamation per se items. The things that if you say are presumed to damage somebody's reputation. Otherwise, defamation is one of the only intentional tort that requires some type of damages. But remember that, and remember the public figure defense, as well as some of the other things we talked about in defamation. Privacy torts, again, review those, what those are, and kind of what it entails to get those. Emotional infliction, intentional infliction of emotional distress. Again, some outrageous behavior that's causing emotional distress to somebody. Something you've done in an outrageous or egregious way that makes them suffer emotional distress or emotional harm. Abusive process, again, is using the legal process or procedure for something other than the requested relief. So, like what? Could be anything. Could be, threatening to keep suing your neighbor for the purpose of harassing them or something like that. Trespass to land is, again, going onto somebody else's land or causing something to be put on someone else's land and refusing to get off the property or to take it or remove the item when you were demanded. Trespass to personal property, again, is when you use somebody else's property without consent, but you're intending to give it back. You're not intending to permanently keep it. If you're intending to permanently keep it, that falls on the next one, which is conversion, which is basically the civil side of theft. The next intentional tort we talked about was intentional interference with a contractual relationship. And what that is again, if there's aware of a contract and somebody is enticing someone to knowingly breach the contract, it can be a tort. In addition to the breach of contract, it could be a tort as well. The last tort we talked about was that fraudulent misrepresentation. You've represented a statement of fact, intending someone else to rely upon it. They didn't rely on it to their detriment, and it caused damages. So those are the elements of those. Also go through the defenses of them that we talked about in class, because those will be important. The next really important problem is going to be damages. And damages are really going to be an important part for this section to determine what damages are available when. So under all intentional torts, you're entitled first nominal damages. Again, that small monetary amount that just acknowledges that a tort occurred. And again, the example we used in class was Taylor Swift sued a DJ and received $1. And everybody goes, well, how's that possible? That doesn't make any sense. She received nominal damages. That's all she was looking for, because she wanted some type of acknowledgement that this individual had committed a tort against her. Nominal damages, some small amount just to acknowledge that a tort occurred. The other type of damages, another type of damages you can get for intentional torts is compensatory. This is, again, damages to compensate you for your loss. Maybe it's damage to your car, maybe it's damage to your house, maybe it's medical bills, maybe it's lost wages. Pain and suffering falls into this category. Some amount of money to compensate you for what you have lost by that tort. The last type of damages to recover on intentional torts is punitive damages. And what punitive damages are, again, are damages intended to punish the person committing the tort. So some amount of money that's designed to punish or deter that person from doing that behavior again. So that's punitive damages, what those are. The last thing to kind of talk about intentional torts we talked about was the eggshell plaintiff. And what this is again, if you find or you happen to injure a person that is susceptible or prone to that type of injury, you are still going to be liable for the damages, even if they are not reasonable. And again, the way to remember eggshell plaintiff is based upon that Humpty Dumpty. He sat on the wall, and he fell off, and all the king's horses and all the king's men couldn't put him back together again, right? Normally falling off a wall wouldn't kill you or me. Maybe me because I'm fat and not very flexible anymore, but it wouldn't kill you, you're young. But Humpty Dumpty killed because he was an eggshell plaintiff. If you find somebody that is susceptible to that type of injury, you are still liable for their injuries. That was the intentional tort section. The next section we talked about was negligence. When we talked about negligence, we talked about what the elements of negligence was. First, there was a duty. Then there was a breach of the duty. There was some element of causation, that the breach caused the damages, and that there were damages. This is a very important part. Negligence requires damages. No damages, no negligence. Because it is a required element of negligence that there be damages. And then we talked a little bit about what duty existed. So again, the duties existed for individuals, for just normal people like you and me. It's the standard of care, the reasonable man standard, which is that we are to act as a reasonable man would in all circumstances. If you remember, for a professional, it was a little different. It was that you would perform as a reasonable professional would within that community. And if you remember, for a business, it was also a little separate, that a business has a duty to protect the consumer and the public from all known and reasonably foreseeable injuries. So know the different duties and hopefully be able to apply them. Another issue we talked about in class was res ipsa loquitur. What res ipsa loquitur is it's in Latin, means it stands for itself, which means that the mere fact that something happened is going to impute liability without proving the negligence. The example we used here was the exploding soda can, right? Soda bottle. I pick up a glass bottle and the glass is so thin and brittle that the minute I touch it, it shatters. I can recover from my damages without having to prove Coca-Cola negligently designed the bottle, because the mere fact that the bottle shattered seems to prove that it was negligent. That's not a normal bottle. Res ipsa loquitur. The next one that we talked about was negligence per se. What negligence per se is anytime that there's a law, a statute, an ordinance, administrative code, something that requires you to do something. If you fail to do that, you are deemed negligent for the damages. And that's negligence per se. So if you see something on the test or in real life that a law says you must stop at a red light, you don't stop at a red light, you are going to be liable for those damages. It's presumed to be a breach of the duty because you did not follow the law. The next thing we talked about was dram shop rules. What dram shop rules are, again, is anytime someone provides alcohol to people and they overserve someone, they are responsible for all damages that person does. So if that person goes out and gets into a car accident after I overserve them, that's what happens. It is dram shop rules. They are responsible for those damages. Another thing to note for the test are some of the defenses that we talked about. We talked about assumption of the risk. We talked about contributory negligence. We talked about comparative negligence, both pure comparative negligence and modified comparative negligence. So know what those are, know how those apply. The next item we talked about was strict liability. Know what the elements of strict liability are, and also know that what strict liability is. What strict liability means is that you don't have to show that there was intent or that somebody breached the duty. It's presumed that just doing it cannot be done safely. So the example we used again was using dynamite. Manufacturer using dynamite, you could say, I exercised all the reasonable care in the world. Doesn't matter. You're strip mining with dynamite, you're liable for all the damages you cause because it can't be done safely. The other example we used were undomesticated animals. I got a punk monkey. I don't. Wish I did. Be really cool. I can barely handle my children. I can say that because my daughter's right here. She's just too shy to come on camera still. But anyway, if I had a pet monkey, I'll get rid of the daughter for a monkey if anybody's got one. Ow! Quit it. Anyway, if you got a pet monkey, that was my bad shoulder too. If you got a pet monkey, you're responsible for all damages that monkey causes. You're not with a kid, so maybe I'm better off with a kid. Maybe. Anyway, strictly liable. You are liable even though you've done everything reasonably with your monkey. Liable. Just because strictly liable. Next thing we talked about in the class was product liability. Now what product liability was, there were 3 different theories of product liability. One is manufacturing defect, where there is some defect in that particular product. The example we gave here was Oreo cookies, right? No cream filling in the middle, right? Every other Oreo cookie in the world has got cream filling in the middle. This one didn't. Design a manufacturer defect, some type of defect in the manufacture of that particular product. The next one we talked about was a design defect, which affects all the products in that product line. We talked about the Ford Pinto in here, where the Pinto had wires that were close to the gas tank so that if it was rear-ended, they would frequently start on fire. It was designed in such a way that it was a bad design. Every Ford Pinto was the same. The last theory of product liability that we talked about was a failure to warn. And what that is when the manufacturer or reseller of a product knows that there's a risk to the product and they fail to adequately warn it, warn the consumer about it. The classic here is, again, turn on your TV and wait for a medication commercial to come on, right? If you have an upset stomach, take this medicine. It may cause dizziness, loss of vision, hearing loss, excess vomiting, and maybe death. There's your warn. If they know about a risk and they fail to warn you about it, they can be liable. So if they knew it could cause death and they didn't warn you that it could cause death, they could be liable for that, which is why when you watch those on TV, you hear that. Another important thing to remember about products liability is applying our other tort principles to them, like negligence and negligence per se. And defenses of assumption of the risk. You took a product that you knew was dangerous and used it anyway. So those are also good. Also know the strict liability elements of putting products in the stream of commerce and how that can apply to strict liability. Basically it is that if you have a design defect or a manufacturing defect, ultimately you're going to be strictly liable for those damages. The last thing we talked about in product liability was warranty. Now, this is not warranty of the latest thing. What iPhone are they on, Molly? Is it iPhone 8? She's too shy to even talk. iPhone 8. You buy your new iPhone 8, right? And you open up your thing and you got a warranty that's 8 little pages folded up like this because they got to fit in the little iPhone thing, right? That's not what we're talking about. That's a contract. Warranty, we're talking about a tort claim of warranty. So what we have is the first one is express warranty. Some statement made by the salesman, by the company, by something, which has expressly said this product does something. So I go to Apple and they say, hey Jeff, your iPhone 8's got a 50 megapixel camera. And I say, that's awesome. I need that because I'm going to take all kinds of great pictures and I'm going to quit being a lawyer and quit being a professor and I'm going to be a photographer. And I need that. I buy it. Turns out it's not. Doesn't matter if the box said it, doesn't matter anything else. That salesman's statement is an express warranty. Next one is an implied warranty of merchantability. And this applies to every single product you ever buy. And what it means is that it has to be useful or valid for the purpose for which they're selling it. The example we used here was a baseball bat, right? We buy a baseball bat and it's made with bamboo first time I line up and swing and hit the ball, it shatters. Breach of the implied warranty of merchantability because it's made with bamboo rather than maple. I think they use maple for baseball bats. So I went to the Louisville Slugger Museum once. I think it was maple, but don't quote me on that. Google it if you're that concerned about it. I guess you'll figure it out. Implied warranty of merchantability. The next one is implied warranty for a specific purpose. And what that says is, again, that if the salesman or the retailer or the manufacturer knew you were using it for a specific purpose and they said it would work for that purpose and it doesn't, they are going to be liable for damages. So warranty, breach of warranty for fit